I'm Robert Lovin from Loyola University of Chicago. It's my privilege to bring this discussion to a close by reintroducing you to people from whom you've already heard. They have been asked to reflect on one significant development or idea that came out of these discussions, and I'll turn, I guess, first to Mark Hill and ask him to offer that reflection. We'll move around the panel. Sir Mark can extrapolate what may have happened. we want to hear from our four panelists, and then open this up for a wider conversation.
I want to tell a short story first, and then to try and bring two themes together, something which caught my attention yesterday. The short story was when I left this room yesterday, slightly before the end of the session. It was not because I was dissatisfied with Nigel's answer to my question. It was because I wanted to attend the choral Eucharist here in the cathedral. And I was taken to my seat, and to my immense surprise, I discovered sitting on my left Lord Justice Mummery. Now, that name may or may not mean anything to you, but if you recall, yesterday, Julian Rivers told us about a judgment which was overturned by the Supreme Court because it lacked any legal common sense. Well, that was a judgment of Lord Justice Mummery. I chose not to share Professor Rivers' views. My observation links something that Nigel said with something that Julian said. And I think there's a huge importance in the way one looks at the established Church of England, the English Anglicanism, as being perhaps a favoured status or a unique status in relation to church and state. And one can argue, as Cecile Laborde did, as to whether that is a virtue in itself, whether it creates an atmosphere in which the sacred is more respected in society and is therefore useful within liberal society. But it's interesting then to read across from that into the detailed discussion which Julian Rivers gave of the Equality Act and anti-discrimination provisions. Because one of the perhaps unintended but beneficial consequences of the equality legislation is that one cannot distinguish between religions. The idea of discrimination is legally outlawed. So curiously, if one has a position of a mildly favoured state church, which is afforded privileges, the very fact that that exists within a legal context of equality has the effect of raising the position of other faith communities to afford them as best as can be equal rights. And I think there's room for argument and reflection on how having an established English Anglican Church is to the advantage of all faiths within the United Kingdom.
Beckwith.
Thank you. I'd like to make a few comments about something that was said first by Roger Trigg as well as Marianne Glendon that I think is worthy of greater discussion. In the legal literature today, at least among philosophers of law, people that do legal theory, there are two areas in which traditional understandings of religious liberty have been challenged. One, some of us have spoken about already, and that is the specialness of religion. The other that I think is worth exploring in greater detail is this understanding that religion is primarily irrational. That is, religion not only can be subsumed, religious liberty can only be subsumed under some other general category, that religious beliefs themselves don't have any intellectual merit at all. And I think that for that reason, I think religious citizens have an obligation, certainly not a legal obligation, but a cultural obligation to be able to make their cases in public to show people that, in fact, their views are reasonable. I don't think that should be a requirement in order to have religious liberty. I don't think laws should require, for example, judges to make assessments of whether a particular religious belief fits some particular canon of reason. But at the end of the day, judges and justices are ultimately influenced by their background beliefs. That is, those beliefs that the general culture believe are reasonable. So, for example, in American history, you have the case in the 19th century of the Mormon Church, which practiced polygamy, and there was a famous case called Reynolds versus the United States, in which this gentleman the law was upheld. This individual was not allowed to practice polygamy. The fine that he had to pay was not rescinded. And yet, years later, we heard actually years earlier with George Washington giving a exemption to the Quakers. Later on, American law tries to carve out exemptions for different groups on a variety of different issues. Why do those groups get exemptions and the Mormons don't? Well, because polygamy just seemed strange and irrational, whereas these other particular views, even though we may disagree with, let's say, the Quakers' view of pacifism, we can see that it's a view that one, let's say, within an identifiable Christian tradition, can make sense of. So I think, my comment is that, or my sort of call to arms is that scholars who are writing in this area should put special care in perhaps taking the time to make a stronger case as to why these beliefs are in fact reasonable and can be defended.
Well, unfortunately, we didn't coordinate before coming up here what we wanted to say to kick off these reflections. So I was planning on saying almost precisely what Mark did, but maybe a little twist. I really appreciated Nigel's remarks on the English arrangement and can the establishment be liberal enough? Coming from the American context, one's instinct is to say, hell no. But I think that's wrong. Actually, I'm enough of a Burkean to think, well, look, if something's been around a long time, that's even as a Catholic, I'm willing to let it slide and say, that's a good reason to keep it. Although I wish you'd give York Minster back. And part of me is also inclined to think that there are, for lack of a better word, sort of Erastian type benefits that one can extract from an establishment type situation. But Nigel took it further and made the point, which I think is really intriguing, that the presence of a mild and equitable establishment, rather than being an insult or an exclusionary device, as it's often framed in American cases, can have the effect of affirming the idea of religion and religiosity as a public good in the public space. And therefore, something like the English establishment can be not an exclusion of, but actually an invitation to people of other faiths to sort of, in a sense, join the Anglican establishment in practicing religion in public. That runs against the grain of where American law on these questions is, but it strikes me actually as having a lot of wisdom to it. And again, wisdom that goes beyond just kind of the Burkean, if it ain't broke, don't fix it kind of position. So I really enjoyed hearing about that.
I'm going to be very cautious, not having been present at the earlier contributions. But I was going just to toss one thing into the pot, really, which is what is the impact of the religious or ethical stance of the decision maker, him or herself, when it comes to resolving these issues on the ground? I've always been interested that in the family division there were 20 of us which had every stance from libertarian atheist through to conservative Christian evangelical, and pretty well all stages in between, and at least one other religion and plenty of none. And what impact, if any, that makes on the decision-making process. I mean, it must make a difference, mustn't it, if you're doing a life-ending case as to what you might believe lies beyond death, if anything. And, you know, completely unrecognised in any conversations that I've ever been part of is the religious and ethical stance of the decision maker themselves. Now, how that ties in exactly, I'm not sure, except that the end of the day, because we are talking about decision making, it seems to be just an issue that needs to be confronted and recognised. Nothing more than that, really.
So this gives us the opportunity to open it, and I see both of our leaders have raised their hands. So let's go first to Nigel and then to John, and then we'll move around.
Thanks very much. I just wanted to pick up a bit on Sir Mark's last remark, because the only part of law I have considered in terms of the impact of the moral, political views of judges on judgments has to do with international law, and just analysing certain cases in disputes over when military intervention is justified in the absence of UN Security Council authorization. It's quite clear to me that the moral and political assumptions of the judges, I guess the advocates, clearly has to shape their views. So I guess my question to you, Sir Mark, is obviously judges are bound by legal texts, by precedent, by rules of legal reasoning. So whatever your worldviews, they're constrained by those. But is there any awareness and discussion among the judiciary of this issue, or is it, as it were, too difficult to discuss?
As far as I know, there is no formal forum within which any such discussions take place, but I've had plenty of fascinating after-dinner discussions in the seclusion of a judge's lodgings about how different people see things. I think I'm merely saying, I think this is something, an issue we ought to be alert to, rather than anything further than that. And if you read, the trouble is that the constraints you've mentioned, for the most part, aren't the material constraints in the kind of cases I've been talking about. We're past all those and into pure discretion. And that's where the status and views of the decision maker can be particularly important. And if you read, say, my judgment in Wyatt in 2004, and you read, say, Anthony Hayman's judgment in Alfie Jones, they reach the same conclusions. I think you'll find that the whole tenor of the judgments is very different to each other because they represent very different perspectives from which we come.
Can I just make one brief comment on that, and that is that if it is in fact the case, as is bound to be the case, that religious and moral and whatever views of the judges is bound to exercise her or his discretion, making that public in what we suppose to be a liberal society is quite difficult, really, because individual views are shaping judgments, public judgments. But that is a fact, and it's unavoidable, and therefore some attempt to theorise how that can be justified would be good.
I just want to join the questions of religious establishment that Nigel and Cecilia and their colloquy last evening, and then Mark Hill and Rick Garnett both raised today. And I came to see, like Rick, that the sticking point is the word establishment. Because the argument for religious freedom that Rick laid out this morning, and the argument for religious establishment that Nigel laid out last evening, track rather closely for a good bit of the way in underscoring the public place of religion in a liberal polity, and the value that that offers to those of religion and non-religion alike. And indeed, the power of religious freedom as an anchor or cornerstone to other human and civil rights is a critical premise in the whole argument about why religious freedom is important. And so I think the difficulty about the use of the term religious establishment is what the American tradition has long held up as the underside, or the underbelly, or the dark side of religious establishment, namely the repression of the religious dissenter, the forced conformity, the penalties of those that fail to conform, the mandatory tithes and other things that are imposed, sometimes the more horrific applications of the establishment and the deprivations that it occasions. But the version of establishment that you, Nigel, were arguing for, the post-1920s version, as you called it during the Q&A, is pretty close to the kind of strong support for religion or religious freedom that Rick Garnett was calling for. And in some ways, the differences are, well, do you have a mandatory or an elected set of religious officials in your high chamber? Do you have a mandated person who participates in coronation as opposed to simply leaving to the president to decide which religious official to have at the coronation? We have actually converged, ironically, on a lot of the goods of religion. You call it a soft religious establishment. We call it robust religious freedom. But 95% of the way, we're on the same place.
Roger, and then
Could I just pick up on the issues that have been raised about conflicts between rights and therefore the need to be pragmatic, as Mark was talking about this morning? And I just wonder, the phrase reasonable accommodation is often raised nowadays, particularly about, for instance, the conflict between freedom of religion and equality rights. And I just wonder if the panel feel that that is somewhere where we could go, whether it does offer clarity or just further obfuscation.
My name is Kurt Remele. I'm from Austria, Graz in Austria, and currently I'm a visiting fellow at the Center for Theology, Ethics and Public Life. And when I was a young man, about 17, I was an exchange student in the United States of America, and I lived with a Mormon family, and I learned a lot about Mormons and other things. You were talking about the Mormons and polygamy in the 19th century. At the time I was there, that was in 1973-74, it was still prohibited for people with black skin to become a minister, a priest or a bishop in the Mormon church. And we heard that the ministry in the church is the requirements are defined by the church, and the state is not allowed to interfere. So my question, if the Mormon church would still have been approved of polygamy in the 20th century or in the 19th century, and just allowed its ministers to, or said ministers of Mormon belief in the Mormon church have to practice polygamy, would that have been okay because the state couldn't interfere? And now, because our culture and values change and also religions change, could you argue that today the state at least would have to interfere in some way if black people couldn't become priests? Then of course the question is, and if women can't become priests in the Catholic Church and the Southern Baptists, is not that an issue of human rights?
Let me first address the Mormon question. It's complicated because in the 19th century, where the Mormons were living in Utah, it was a territory, and so the federal government passed a law prohibiting polygamy in the territories. The other problem has to do with the fact that not only was polygamy, the practice of plural marriage as a civil matter prohibited, it was also cohabitation was prohibited. So up until I think 3 or 4 years ago, and Rick could correct me if I'm wrong here, Utah was the last state in which cohabitation between more than 2 people was actually criminalized. And there was a case in Utah that said, no, this violated the right of privacy. So in Utah, at least, you still couldn't practice polygamy at all, even just religiously. Right now, there are groups that are perfectly permitted under the jurisdiction of their own religion to, in fact, practice plural marriage, but it's not recognized by the state. So, I mean, there's a distinction here I want to make between the legalization of a particular practice versus the legal recognition of a practice. So, in the United States right now, you could belong to a religious group that allows polygamy, a man married to 4 or 5 individual women. That's perfectly legal to do, but the state will not recognize it. Absolutely today, but ironically, it was in order for Utah to enter the Union in the late 19th century. Not only did it have to forbid the state recognition of plural marriage, but also prohibit cohabitation of any sort. So it couldn't be practiced religiously at all. So your next question, in American law, no, you can have, as Rick spoke about already, the what is called the ministerial exemption. Religious organizations can choose anybody as their ministers, and they can discriminate based on gender or race or anything of that sort. Now, an interesting case that was brought up by Martha Nussbaum several years ago, she was interviewed, I forget in what magazine. She said that Catholic universities, many Catholic universities, are run by religious orders, which only allow, obviously, men to hold the priesthood, and the presidents have to be a member of that order. So she made the argument that she believes that tax-exempt status from those institutions should be withdrawn based on the fact that they discriminate in terms of choosing their president based on gender. So there are some voices that are making that argument, but in terms of American law, I don't think there's any doubt about it. Yeah.
Well, no, I was going to respond to the reasonable accommodation point, so perhaps I ought not to interrupt this.
Well, just a quick follow-up on this. In addition to Professor Nussbaum's point about some of the universities like my own that have rules regarding the presidency, it was the issue was raised in the Supreme Court during the same-sex marriage case of Obergefell, whether religious and other institutions that oppose same-sex marriage should, on public policy grounds, lose their tax exemption, as had happened to some groups that opposed, that had racist views in the 80s. And the lawyer for the government said, paraphrasing, that's going to be an issue, which raised a lot of concern. So there are, in my business in the States, there are academics who'll say, kind of shorthand, the Catholic Church should get the Bob Jones treatment based on its ordination practices and its views about marriage.
I was just going to respond to the reasonable accommodation. The trouble is that the moment one uses the word reasonable, you introduce the possibility of disagreement. And I think one of the problems very often is that where you have a conflict, there is more than one reasonable solution to it. And you have to choose which one, because not because one's more reasonable than the other, but because you have to choose one. I suspect reasonable accommodation will be subsumed with the same arguments that attend proportionality. That at the end of the day, you're saying you're erring on the side of respecting freedoms, but you're recognizing that if they impose on other social goods, they may have to give way, which you can call reasonable or proportionate or whatever. So I think they have a tendency to be helpful in the sense that if you use the word reasonable, it means people have got to produce reasons. but I think it also may lead to obfuscations because you can normally produce a respectable set of reasons for more than one course of action. And I'm not quite sure where that one takes us at the end of the day, except to recognise that, you know, that's the kind of messy world we live in.
Jessie Giles from the Open University. It's a general comment, but in particular to Sir Mark Hedley, if I may. So I worked for a number of years as a law reporter in the High Courts of Justice for the Incorporated Council of Law Reporting. And I have the hugest admiration for our judiciary. It's not flattery, it's just a statement of my observation. And I always observe the thoroughness with which cases were explored and conclusions were reached. The comments I'm going to make then subsequently that follow are outside the family courts. I wasn't in the family courts. But I think over time, I observed, and in fact a PhD student who I work with also undertook an analysis of judgments. There was a lack of willingness to observe or support religious freedom claims over time, and it's a generalisation. And I saw it in particular, for example, with a judgment, I take one, of Mr Justice Cranston in the Guy case, where at first instance he gave this textbook example and thorough analysis of the religious freedom claims. He called expert evidence about the religious beliefs in that case. It went on appeal into the Court of Appeal, and the case was resolved on what constituted a crematorium, and actually you could have a retractable roof, and so the whole case could be resolved in that way. So there was a drive to avoid the religious disputes in that case. And I just wonder actually whether the fault lies with us, and by with us I mean the general public, in that we don't want religion to be discussed, and therefore the judiciary are feeling that, if you like. Again, it's all very amorphous, but that's the impression that they have, and therefore they are seeking to avoid, we're having that avoidance of that discussion in the courts.
Sorry, do you want me to respond? Yes. Yeah, sorry. I mean, I think your analysis is fundamentally fair, I think. I think there is always a tendency from a judicial point of view to resolve each individual case in accordance with its own facts without setting precedents if you possibly can, which is a terribly English thing to do. There's also a tendency to resolve a case on the least contentious principles that are involved. And of course, freedom of religion is usually amongst the more contentious. So whether sliding roofs or not amount to a crematorium is a very convenient way out, which at the same time is a proper decision in terms of the statute then to be construed. And I think there is a general disinclination amongst judges to pick what they see as unnecessary fights. A good example was James Mumby as a first instance judge in Burke attempted to set out to define best interests. And pretty well the entire judiciary ganged up on him to say you can't do this. And in fact, the Court of Appeal were unspeakably rude about it. And I think that was just an example, probably, of the culture which you have detected. Whether the country wants us to be bolder about it, I'm not actually sure. And I'd be interested to hear what any others say about this. But I see that culture precisely.
So both the question and the answer remind me of, there's a colleague of mine in the States, Cass Sunstein, who talks about deciding cases, and the matrix he sets up is decisions can be shallow or deep, and they can be narrow or wide. And that all things being equal, go for the shallow and narrow as opposed to the wide and deep. And that strikes me as a pretty good way to frame the issue, actually.
The other thing you tend to get, of course, which happened to me, counsel come in and they tell you this is the case that's going to resolve the great issues that have been debated about for ages. What they've forgotten is that you're going to find the facts. And the facts may just somehow not highlight those issues and dispose of the case on an entirely different basis.
Thank you. Simon Lee from the Open University. There some extraordinary things said and left unsaid yesterday. I'd just like to pick up two and see if the panel or perhaps Nigel would like to comment on them. Both in the last session. One is that Cecile seemed to think that she couldn't become the Queen by virtue of being Catholic. And I wouldn't like Americans to go away not understanding our law. She could become the Queen, thanks to the succession to the Crown Act 2013. On the assumption that she's a Roman Catholic, she can still become the Queen. What can't happen is for a Roman Catholic like me to become the King, for example of gender discrimination. Because George Windsor, the Earl of St Andrews, is the 36th in line to the throne and is married to a Catholic academic at Cambridge. And the succession to the Crown Act restored him to the line of succession. So, put it another way, Meghan Markle, who's become an Anglican, if she was to become a Catholic, and if the line of succession would go that far, she could still become the Queen. So be reassured about that.
We Catholics still think Meghan Markle is a Catholic.
So does God.
But secondly, and more importantly, I'm amazed that Nigel missed an open goal, and I'd like to know why. He didn't entitle his paper with a single and very long word, anti-disestablishmentarianism. That seemed to me to be what it was. It wasn't really an argument for establishment. It was really an argument against disestablishing the church, unless you've got something better to think of to replace it with. So I'd like to hear thoughts on those.
On the issue of Catholics succeeding to the throne, I guess I'm not on top of that one, so I'll just let your comment rest. But it isn't quite so bad as perhaps was supposed yesterday. On the, yes, on when my paper was really an argument about keeping what we got, because there isn't anything better. No, I think if you remember the first half of the paper, which was a concern about what are the sources of a liberal culture necessary to sustain liberal laws and norms. And the suggestion was that not at all that that the state promotion of a certain version of Christianity is sufficient to do the job. It certainly isn't. I mean, civil society has to produce the culture. My more modest question was whether the state has any role at all, and I suggested it should have, because the issue is a serious one, and that therefore Anglican establishment has a positive value for anyone who cares about a liberal culture. So that was a more positive, I think, justification. Yeah.
Can I say, I've been proved manifest wrong. When Simon Lee put up his hand, I knew, or I thought I knew, exactly the point he was going to make, and he completely wrong-footed me by making another one. So I'm going to answer the question I thought he was going to answer. Simon Lee constantly reminds academic audiences of the decision in Johns and Derby City Council, where the appellant advocate, armed with an affidavit from George Carey, the Archbishop of Canterbury, made an impassioned plea for the appeal to be heard by a hand-selected tribunal of overtly practicing Christian judges. And he got short shrift. He was told in very clear terms that judges, all judges, make a judicial oath of impartiality, and that you're not going to get hand-chosen judges dealing with individual questions. And the judge who got so irate that that argument was being put by counsel was Lord Justice Laws.
Now, do we have one final question? I'm really quite surprised that the audience has been reduced to silence.
come up
Yeah,
with
there's, other presidents want to raise question, and I want to make some comments on some of my observations about the conference. It seems to me that the nature of freedom of religion has been taken for granted throughout the conference. I think we need to make clear the nature of religious freedom first, in order to understand why there's tension between other social goods, equality and religious freedom. It seems to me that religious freedom is freedom of practice our religious beliefs, someone's religious beliefs, which includes belief in a certain religious doctrines, express someone's religious doctrines, persuade others, and form communities, a religious community. But if that is the case, then I think religious practice is never private activities, and that has huge implications for our thinking about religious freedom. Because some people think that religious freedom is to affirm our private spheres in which we engage our religious activities. And I think that is a wrong picture. If we take religious practice to be something social, not private, then I think the religious practitioners have to prepare the society to step in, the government to step in, or the public to step in. This is what I have thought about the nature of religious freedom. I want to share with you.
Final comments from anyone on the panel? And let's thank all of our